Thank you. I am hoping that because my dear friend DeAndre Brooks did not take advantage of his allotted time, that I may be seated some of this time. I do not want to talk too fast, but I do have lots to say, and I wasn't made aware that we were going to be reduced down to 10 minutes. So I'm going to try to do the best that I can do and stay within the confines of time. But thank you. My name is Genevieve Jones Wright. And I really want to thank you for this opportunity to present testimony on the history of policing in San Diego. As you all well know, we cannot divorce our current policing systems or any system in this country for that matter from their racist roots in white supremacy. Slavery existed in this country before it was a country, and the effects of slavery still persist in today's society. The biased policing we see in our communities is firmly rooted in the systematic mistreatment and dehumanization of Black people. It is easy to directly correlate what we see in our prisons and our jails as far as numbers with what happens in our courts as judges sentence people to prison and jail. What I have seen in my law practice as a criminal defense and civil rights attorney, however, is how policing directly impacts what we see happen in our courtrooms. When a person has more contacts with law enforcement because they live in an over-policed neighborhood or because their skin is seen as a threat to police officers or as probable cause, they will have more involvement with the criminal court system. As we have discussed earlier through earlier testimonies, after the Civil War, slave patrols were used to round up newly freed men and women. Their violation, walking around Black and free. And unfortunately, this violation still results in a disproportionate rate in which African Americans engage in the criminal legal system. In the overview of my testimony, I wrote that California's vagrancy and loitering laws were spawns of the Black codes and the Jim Crow laws that were prominent in Southern states. This by no means was meant to infer that these racist laws never made their way to California. They most certainly did. Segregation was firmly established in California in 1870. And what's not commonly known is that the California Supreme Court upheld a law mandating school segregation, holding that the 14th Amendment to the U.S. Constitution did not bar segregation. 20 years before the United States Supreme Court adopted this rationale in its infamous Plessy versus Ferguson decision. So, although California entered the Union as a free state in 1850, prohibiting slavery in our Constitution, it enacted its own Jim Crow laws between 1850 and 1947. The criminalization of societal issues like homelessness are consistent with the early days of policing, where vagrancy and unemployment were policed formally through Black codes that we also heard about earlier that severely restricted the freedom of Black people living in the South. The defining feature of Black codes was broad vagrancy laws, which allowed local authorities to arrest freed people for minor infractions and commit them to involuntary labor. It is worth noting that homelessness is heavily criminalized in San Diego County, and that Black people make up 22% of people experiencing homelessness, despite only being 6% of the population. And that, as Voice of San Diego reported in 2020, African Americans were disproportionately impacted by the enforcement of rules relating to the COVID-19 pandemic, despite the overall number of arrests and tickets in San Diego falling dramatically after public health officials ordered people to stay home. A Voice of San Diego analysis of San Diego Police Department crime data found that 1 out of every 4 violations of various emergency orders went to a Black person. They went further and explained that it wasn't just in the category of public health where Black San Diegans were overrepresented. Indeed, the very history of California starts with anti-Blackness. California's first governor, Peter Burnett, in his first State of the State address remarked that after much reflection, he determined that keeping Black people out of California altogether would be the best policy. California's first governor pushed for a complete ban of Black people from entering the state as one of the first items of business for the newly formed state, and so did some of the men who wrote California's Constitution. It is with this backdrop of history that I offer my testimony on the history of policing in San Diego this afternoon. I will lift up the stories of 3 valiant Black men I believe are critical to understanding how policing in San Diego is directly tied to the need for white people and particularly law enforcement actors to maintain and exert control over Black bodies. I hope to help this important task force understand how policing practices, norms, cultures, and their detrimental effects, all rooted in white supremacy, continue to affect Black communities today, and why it is important to dismantle our criminal legal and policing institutions as they now exist. When the San Diego Police Department was established in 1889, one of the prerequisites for being a police officer was being a white male. It's no wonder that when the first Black officers joined SDPD, they were forbidden by their superiors to arrest lawbreakers if they were white. Now think about that. And how could a Black officer testify against a white offender when California's Jim Crow laws did not allow non-whites to testify against white people in a court of law? This brings me to the story of the grandfather of one of my oldest friends from childhood. Detective Johnny Williams joined the San Diego Police Department in 1952 as a quote-unquote beat cop. He was one of the earliest African-American police detectives in San Diego, and he served with distinction 26 years until 1978. During his tenure, he was known for his exceptional investigative and interrogation abilities, notably carried out with fairness and determination to do the right thing. His skills were so remarkable that some of his interrogations were used as models statewide in recruit training. As outstanding as he was assigned to work only with other African American officers and only in cases that involved African Americans for many years on the force. And as a matter of policy, he was expressly prohibited from arresting white offenders. Being the honorable man he was, he took his oath seriously, and Detective Williams did not comply with that prohibition. These were the stories that he told his children and grandchildren. And these stories of discriminatory practices within SDPD were later confirmed in an interview published in 1996 through the words of Detective William Ritchie, who joined the San Diego Police Department in 1935 before Detective Williams. I share with you about Detective Williams to illustrate how profoundly policing is rooted in white supremacy. If a Black officer was not worthy enough to confront or arrest a white man who was breaking the law, how will a Black man or woman be seen as worthy of respect and human dignity when encountered by a white cop on his beat? What prevents the actors within police institutions from treating every Black person they see as a criminal or as a threat or a gang member who needs to be neutralized? Which brings me to the story of Sagon Penn. On May 31st, 1985, Sagon Penn, a 23-year-old Black man, was driving his car in the Encanto neighborhood of Southeast San Diego, where I live, when he and his passengers were racially profiled as gang members by 2 San Diego police officers, Donovan Jacobs and Tom Riggs, despite none of them being involved in gangs or having a history of doing so. Upon being stopped, Penn, a beloved member of the community and a prolific martial artist, was met with what was intended to be offensive and provocative gang language before he was asked for his ID. What ensued was a beat down by Riggs and Jacobs, who began to kick, punch, and beat Penn with a baton. Despite Penn being on the ground with an officer on top of him holding him down and him yelling, "I give up, you've got me now," the officers continued to beat him. Penn defended himself as he had every right to do, managed to block some of the officers' blows, and gained possession of Jacobs' revolver, killing Jacobs and injuring Riggs and their ride-along passenger. Penn was also wounded during this episode of gratuitous police violence. Notably, a fellow officer testified in support of Penn and testified that Officer Jacobs was a quote unquote racist hothead. The San Diego Police Department and its chief, never ones to engage in self-reflection in any meaningful way, criticized the DA for not seeking the death penalty and denied any wrongdoing on the part of the officers. After 2 trials, Penn was acquitted of the murder, attempted murder, and manslaughter charges. Not only was the Black community outraged about the police abuse that unfolded during Penn's traffic stop, but so was the judge who presided over the trials. Law enforcement's flagrant abuse of Penn that night was not unique to Penn's situation. It was emblematic of the day-to-day interactions between members of San Diego's law enforcement and the residents of southeastern part of San Diego, which houses the greatest concentration of Black residents in the city of San Diego to this day, as DeAndre Brooks just spoke about. This particular incident of police violence and abuse, however, was a catalyzing force that brought about San Diego's first review board on police practices, which was supposed to be a check on police misconduct. This type of police abuse is not the only mistreatment Black San Diegans were and are still subjected to. African Americans in San Diego are victims of over-policing and arbitrary and selective enforcement of our laws, which stem from bias in policing, which is rooted in white supremacy. Emblematic of the harassment that Black San Diegans are subjected to is the U.S. Supreme Court case Colander versus Lawson. Edward Lawson was detained or arrested on about 15 occasions between March 1975 and January 1977, pursuant to California Penal Code Section 647E. At the time, this penal code section prohibited persons from loitering or wandering upon the streets or from place to place without apparent reason or business and refusing to identify themselves to account for their presence when requested by a peace officer to do so if the surrounding circumstances are such as to indicate to a reasonable man that the public safety demands such identification. I know, that was a lot. From the trial transcript, we learned that the stops of Mr. Lawson were arbitrary in nature. On the first occasion, Mr. Lawson, who was new to San Diego, was simply walking home from a party on what he called a beautiful San Diego day and was arrested for violating Penal Code Section 647E. And as he recalls, as he got out of jail for this first offense, he was cited again. It's important to note that Lawson had never been stopped by police for any reason apart from his 15 or so detentions under this law. In his own words, he would, quote unquote, just be going to the curb or leaving his residence while living in La Jolla when detained or arrested. And it shouldn't be lost on us that La Jolla is an affluent area known for its history of redlining and restrictive covenants keeping Black people out. Lawson found during conversations with his friends that these citations were commonplace for young Black people. He decided to fight his citations on constitutional grounds. No one would take Lawson's case, so he fought the citations representing himself all the way to the U.S. Supreme Court and won. The named defendant in Colander versus Lawson was Bill Colander, who was the chief of police of the San Diego Police Department at that time and who later became San Diego County's sheriff. True to form, the San Diego Police Department and its chief could not accept an adverse ruling and appealed the case all the way to the U.S. Supreme Court. Now, while striking down this statute really set an important precedent, the underlying facts that brought about this case in the first place are crucially important and deserve attention. So let's go back to the Black codes and Jim Crow laws. This California statute was being arbitrarily enforced against Black people as a means by which law enforcement could and did monitor and control the actions of Black people in San Diego. And this was not lost on Mr. Edward Lawson, who likened his experience and the experience of other people like him who were being harassed by law enforcement by way of this statute to the past laws in South Africa during apartheid. The past laws of 1952 required Black South Africans over the age of 16 to carry a passbook everywhere and at all times. The pass laws was a system used to control the movement of Black, Indian, and colored people in South Africa. I share these stories because each of these men stood up and fought against the system that was determined to subjugate them, and in some cases commit violence against them and change some aspect of policing in standing up. But while honoring their acts of bravery and courage and the honoring of their own manhood and humanity, one must not gloss over the traumatic experiences each man had to endure. Sagan Penn paid the ultimate price. In his case, he was never able to have peace. Despite his acquittals, he was a constant target of the San Diego District Attorney's Office and local police agencies. And for the next 17 years of his life, Sagan Penn endured their constant harassment and struggled with mental health and other issues as a result of the traumatic experience on the night of May 31st, 1985. Sagan would tell his friends and family that he couldn't have a life as a result of that fateful night. Sagan Penn was liberated from the constant harassment in this life on July 4th, 2002. Finally, in honoring their stories, we must also acknowledge not only that white supremacy underpins our policing institutions and systems, but also the need to rid ourselves of it. Although the data is clear that African Americans are policed differently in San Diego, the city attorney nor any of her representatives made any mention that San Diego's outdated seditious language laws were selectively enforced in a discriminating way against African Americans when they decided to repeal it back in 2020. And even after commissioning their own reports that confirm that Black drivers are stopped and searched disproportionately when compared to their white counterparts, both the San Diego police and sheriff departments have doubled down on their arguments that these quote-unquote disparities don't equate to bias or discriminatory policing. We know that given the history of policing in this country and in this state, we cannot separate the fruits we see from the root of white supremacy and institutionalized racism. For this reason, I ask that this body consider proposals that will result in a complete reimagining of our criminal legal and policing systems and address collective trauma. I don't believe that we have two justice systems. I don't believe that this country is home to any justice systems. I also don't believe that our criminal legal system is broken. It is working the way it was intended. That being said, I thank this task force again for allowing me the opportunity to share a few thoughts and, of course, for undertaking this great work.